Good morning, can you hear me? Rosie Smith, can you hear me?
Yes, I can.
Hi, okay, 1 second, please.
No, I got it. Why did you wait till I shut off the car?
Kaylin, can you hear me?
Yes, I can hear you.
Is your last name Kilgore? Ma'am? You're muted.
Yes,
Is it your last name Kilgore?
yes.
Mr. Court, can you hear me?
Hi, yes, I can.
Good morning. What case are you here for?
I'm here on Butler.
Oh, Adrielle, are you representing Butler?
Yes.
Thank you.
Mary Ann, are you there?
Good morning. Yes, how are you?
Hello. Well, I just saw the judge come in. I was going to speak with Mr. Court briefly, but I'll let
Okay, I made you co-host, Mr. Morton,
okay.
whenever you want to move around.
Wasn't sure if Judge Martin wanted to say anything first before I leave the room.
Oh, good morning. Today is Wednesday, September 27, 2023. I'm Judge Martin. This is courtroom number 1. Today's cases are exclusively landlord-tenant matters. If you don't have a landlord-tenant matter, you are in the wrong courtroom. You may send a message to Mary Ann, my secretary, and she'll help you get where you are supposed to be. Other than that, there are 36 cases scheduled in the next hour. So what we'll do is we'll call the cases. If there's an agreement, we'll place on the record. If not, we'll put you into a waiting room where the attorney for the plaintiff will meet you to discuss the matter more thoroughly. But for right now, let's see who's here, see where we have agreements. Other than that, okay, Mary Ann,
Yes, ma'am.
great. Looks like the 9 o'clocks have started going into the bench file. So let's look at 2300362 LT. This is Harbor Club versus Smith.
Yes.
State your name for the record, please, sir.
Boyd v. Smith.
Thank you. Today is the day and time set for the second hearing in this matter. Mr. Morton, what is the rent to retain possession?
Your Honor, at this time, rents retained is $3,742.00. Also, Ms. Cooper, I believe Ms. Cooper is representing Mr. Smith on this one too, Your Honor.
I am, Your Honor. I believe we have an appearance. We filed it yesterday.
I don't have an appearance. I don't have the appearance, Ms. Cooper. Thank you. My apologies.
No, you're okay. Catherine Cooper on behalf of the defendant, P85148.
Your Honor, I'll just complete my statement. So rents retained are $3,742.00. Court costs are $168.65 for a total of $3,910.65.
Thank you. Ms. Cooper.
Your Honor, I emailed Mr. Morton's office. I don't know if you saw those emails. Ms. Paglia copied you on them, Mr. Morton, but we're trying to assist Mr. Smith with some rental assistance through Wayne Metro. There is a new rental assistance program. They pay up to 6 months of past due rent. So we were hoping to assist Mr. Smith in that matter and try to work out a resolution.
In this one, Your Honor, I think it's appropriate for the parties to be put into a breakout room to be able to discuss this matter further because there is a significant balance right now in the account as well.
Thank you. Let's get Ms. Cooper into your breakout room. We'll check with your other tenant that is present, and then we'll send you in there, okay?
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. This is 2300339 LT. This is Harbor Club versus Butler.
For the record, Your Honor, Attorney Ian Morton, Palace Law on behalf of the plaintiff.
Good morning, Your Honor. Raymond Court with Lakeshore Legal Aid appearing on behalf of Ms. Butler.
Ms. Butler, unmute yourself, turn your video on, and state your name for the record.
My name is Ardriel Butler.
Thank you. There's also a Kaylin Kilgore and a William Bryant.
William Bryant is here.
Do we know where
Kaylin
Kaylin Kilgore is?
Kaylin
Thank you.
Kilgore
Take
is
your
here.
hood off. This is court.
I could have told you that.
Thank you. Mr. Court, I don't see an appearance on the docket that was run yesterday. Did you file one with the civil department?
Yeah, it would have been filed mid to late afternoon yesterday, Your Honor.
Have you had a chance to speak to Mr. Morton or anyone from his office?
Not yet this morning. I emailed him yesterday and he asked if we could speak this morning.
We'll get you moved into the breakout room. I think that Yep, those are all, both of Mr. Morton. Nope, there's one more case. If you move into the breakout room, I'll call the Lambert matter and then I'll get Mr. Morton in to meet with you.
Thank you, Your Honor.
This is 2300348 LT. This is Harbor Club versus Aaliyah Lambert and Karen Kendrick.
Yes.
For the record,
Turn
Your
your
Honor.
video on and state your name, ma'am.
Okay. Celia Lambert.
Thank you, Ms. Lambert. Where is Karen Kendrick?
She is not with me right now.
What does that mean, not with you?
She's not here. I'm packing, getting all my stuff out this apartment. She's not here. She's in a wheelchair, so she's not here. We were supposed to be out
Okay.
yesterday, but they say I could.
You were
just
supposed to
come
be
in.
out what? I'm sorry. You were supposed
I
to
was
be out
supposed to be
what?
out yesterday, but they told me that we can just finish moving our stuff today.
Thank you. Mr. Morton, this is the second hearing in this matter. What's the rent to retain possession?
At this time, rents retained are $4,877.50. The court costs are $190.65 for a total of $5,068.15.
Ms. Lambert, were you able to hear Mr. Morton just now?
Not really.
He indicated that the rent that is past due is $4,877.50. Plaintiff is also requesting court costs of $190.65. Is that amount of rent accurate?
Yeah.
Yes?
Yeah.
Ms. Lambert, in as much as you acknowledge and admit the amount of rent claimed due is accurate, there is not a tribal issue of fact, and plaintiff is entitled to entry of judgment in the amount requested. Mr. Morton's office will submit a judgment to the court that has that dollar amount on it. It will indicate that you need to pay $5,068.15 within 10 days of today's date or vacate the property. I heard you indicate that you're moving out. So once Mr. Morton's office sends that proposed judgment to the court, a copy will be mailed to you at the address that we have on file in this matter. If you do vacate the property, you do need to provide the landlord with a forwarding address. Understood?
Yeah.
Any questions, ma'am?
No.
Thank you, ma'am. You're free to go. You have a wonderful day. Mr. Morton, if you want to go ahead and move in with the attorneys.
Yes, Your Honor, I'll move the parties around, and then Ms. Polya from my office is also present if other people can start to show up as well, Your Honor.
Thank you, because Mr. Pantel is here. Once he takes his hat off, I'll call the case.
I'm sorry.
Thank you. This is no worries, 2300353LT. This is Harbor Club versus Brandon Pantal. Your appearance, sir. Your name for the record, Mr. Pantal.
Brandon Pantal.
Thank you.
And Danielle Polya for the plaintiff.
Ms. Bogley, today is the day and time set for the second hearing in this matter. What is the rent to retain possession, ma'am?
I have rents to retain of $2,900, court costs of $168.65 for a total of $3,068.65.
Thank you. Mr. Pantal, were you able to hear the attorney just now?
Yes, I was.
Is that amount of rent accurate, sir?
Yes.
Do you have any defense to this non-payment of rent case?
No, it's just, I had everything's been hard. I had a vehicle that went out. It cost me $5,000 to fix. I had another vehicle go out that's costing me some money. It's just been hard, and I have kids, so I'm trying to. Sometimes you got to pick when you're in a tough spot to feed your family. So I took out a hardship loan off my 401k for $3,500, but they said that could be another 2 weeks before I get that money in my account, and I get paid tonight like $2,200 from my business I work at. So I'll be able to pay some tonight, and then once I get the rest of that other money, I'll be able to pay the rent.
I'm gonna have to call you back. I'm at grandma's and we're waiting to do the Zoom meeting with the court.
I'm sorry, whoever that is that's interrupting the court session. I'm sorry, sir, you were saying that you get paid tonight and your plan was?
I could pay a good part of it tonight, and then I took out a hardship loan off my 401k for $3,500, but they said that won't get into my account for another 2 weeks, and I could pay the rest once I get that money too. So
Okay, sir, what will happen is that the judgment that the plaintiff's office submits will indicate that you will need to pay that $3,068.65 within 10 days or vacate the property. That's what the judgment will say. The court does not get involved in how you make payments on the judgment. That's something that you typically have direct discussions with the property manager or the leasing office about. So
Okay.
I hear you indicate that you have money coming tonight and then money
Yeah,
coming in a
I
few
could
weeks.
be able to pay half of it tonight, and then, like I said, I got another chunk coming. It said 10 to 14 business days when I filled out this paperwork. It's a hardship loan off my 401k. So, and that was for $3,500 I was able to take out. So I just go to my property manager and talk to him about that.
Yes, sir. You make arrangements. I see the attorney's office making notes about it. And what
Mhm.
will happen is, so long as you've made some arrangements that is typically sufficient to help you continue to make payments, is when people don't do anything, that landlords come
Alright.
come back to the court for the next step, okay?
All right. I appreciate it.
Do you have any questions, sir?
No, I don't.
What will happen, as I indicated, is Ms. Paglia's office will submit a judgment to the court that shows those dollar amounts with the 10 days to pay or vacate. I'll sign it, and then a copy will be mailed to you at the address that we have on file, okay?
Okay.
Good luck
Sounds
to
good.
you, sir. You have a wonderful day,
I
okay?
appreciate it. Take care.
No worries.
All right. Bye.
Goodbye. This is 2300346 LT. This is Harbor Club versus Hamlet and Hamlet.
For the record, Danielle Paulia on behalf of the plaintiff.
Ms. Hamlet, please turn your video on, unmute yourself and state your name for the record.
My name is Tatiana Hamlet.
And where is Michaela Hamlet?
Michaela Minchell.
Who's driving?
I am.
We're going to pass the matter until the car is no longer in motion. Thank you.
Okay, I'm gonna stop the car.
Duena.
I stopped driving.
I see, thank you. On the Hamlet matter, Ms. Paglia, what is the rent to retain possession, please?
I have rents to retain of $3,040.68. Court costs of $190.65 for a total of $3,231.33.
Thank you. Ms. Hamlet, were you able to hear the attorney just now?
Yes, I was able to hear that.
Is the amount of rent claim accurate?
I do. I believe so. It's accurate.
Do you have any defense to this non-payment of rent case?
Yes, I have multiple defense. My car was recently just broken into, and it was no cameras or anything that was in the facility or anything. And I was found out that there was supposed to be a type of security that ended up being almost $2,000 in expenses. As well as my DTE. My DTE has been outrageous since I've moved in. I've went to the leasing office and spoke to them plenty of times to get help about it, but I've never received help by it. Another defense that I needed to mention was my bathroom ceiling. My bathroom ceiling was falling down. I actually have pictures of it, but I wasn't able to get a copy of it to show you guys, but the ceiling was falling down. A complaint was mentioned. The maintenance man came out once and he told us that he was going to come out again to fix it because he's seen that there was a problem, but it was never fixed. It was marked as finished and totally disregarded along the line. So with the rent being due at its expenses right now, the reason I haven't been able to pay it is because of the outrageous bills I have been having to pay and the coverage of my vehicle with no type of answers or help or anything like towards the rent other than pay rent.
Well, ma'am, in as much as you are disputing the amount of rent claim due and owing because of repair issues, what the court will do is set this matter for hearing. Mary Ann, next Wednesday, the 4th. In the morning, do we have anything on the docket?
Give me 1 second, Judge.
Thank you, ma'am.
You do not have anything scheduled.
Hello?
Next Wednesday morning at 9 a.m., Ms. Hamlin and Ms. Hamlin, are you available?
Next Wednesday at 9 a.m. Could it be on
Yes.
a Tuesday or preferably a Thursday? Because I work these mornings.
Is the afternoon better?
If it's after 3 o'clock, then yes, that will be better for me.
No, ma'am. Tuesday the
No.
3rd?
Yes, I could take a Tuesday on the 3rd.
Ms. Paglia, would your office be available on the 3rd at, let's find a time. There's a civil docket in the morning. Could you do a 1 o'clock next Tuesday, the 3rd?
Yes, I can do that for sure.
We should be able to do 1 o'clock on the 3rd.
In person or Zoom, Ms. Hamlet?
A Zoom is fine.
We have the hearing on this matter next Tuesday, October 3rd at 1 p.m. by Zoom in courtroom number 1. Ms. Hamlet, if there are documents, photos that you want this court to consider as part of that, you need to have them submitted to the court by this Friday.
Okay.
Okay, this court does not have screen share capabilities on the Zoom. Ms. Paglia, so your office would have that same requirement. Any documents that you want this court to consider as part of that hearing on the 3rd need to be submitted by this Friday, September 29th by 3 p.m.
Okay, I can definitely do that.
Anything else in this matter, Ms. Paglia?
Nothing further, thank you.
Anything else, Ms. Hamlet? Ms. Hamlet?
Exactly where would I send the documents to? Like through the email that I got sent from you guys. I was sending it to that.
I don't know what email you received, ma'am.
Okay, no problem. I'll figure it out.
On the court's main website, there's a contact us button where you can send documents to the civil department, or if you're local, you can bring them into the courthouse.
Okay, all right. That'll definitely.
Anything else?
That's it for me, ma'am.
Thank you. If that concludes this matter, you're free to go. You have a wonderful day.
You too. Thank you.
Thank you. This is 23-00097. This is Darlene Olivero versus Kevin Hamilton. Unmute yourself, turn your videos on, and state your name for the record, please. Ms. Olivera does not have audio despite efforts from the staff. See if we can get her to connect. C-930 cases, I don't see anyone else from the 9 o'clock docket or the 9:15 docket. How is it possible? There are no matches right now. Good morning, Mr. Berncrant.
Morning, Your Honor.
Ms. Townsend is here. Would you like to go into a breakout room to discuss the
Yes,
matter
please.
with her?
I appreciate that.
We'll get you moved in just one moment, sir.
Okay, thank you.
Judge, I'm juggling over here. Mr. Berncrant wanted to, Mr. Berncrant, I just made you co-host. Was I supposed to do something with Mr. Berncrant, Judge?
He just needs Ms. Townsend in a breakout room.
Okay.
Thank you.
Mr. Berncrant, can you do that?
I can manage that.
Okay.
It'll
All
take
right.
me a minute
Thank
or two,
you.
but I can handle that. Thank you.
Appreciate it. Thank you.
Mhm.
When I start talking, them, remember, they can hear you. When they're ready for you, they'll come on. Say, Miss Bell.
Ms. Olivero,
Yes.
unmute yourself and turn your video on for me, please.
Okay, it's on my phone, but I'm trying to do it on the computer.
If it's on your phone, that's sufficient. This is a
Okay.
recall of 23-00097 LT. This is Darlene Olivero versus Kevin Hamilton. Please unmute yourselves and state your names for the record.
Darlene Olivero.
Mr. Hamilton? Kevin Hamilton.
Yeah. So it's actually strange. So I'm actually Kevin Hamilton Jr. I'm here for a case for work with the Springkill with Markel Spencer. The Kevin Hamilton that you guys look for is actually my dad. Just a weird coincidence. So and I don't see him in here.
Is he supposed to be in court this morning?
So the last, a few weeks ago when this happened, that's kind of when I found out that it was a coincidence for it, and he was there then. So yeah, I think he's supposed to be. He's not. I could text him.
So yes, he's supposed to be in court this morning.
Yeah.
Okay. Are you sitting in the room with Mr. Spencer?
Yes.
Okay, because you're muted, but the sound is coming from,
Yeah.
okay.
Yep.
Ms. Olivero?
Yes.
Today is the day and time set for the second hearing in this matter. The case was scheduled at 9:15. This court's policy is 15 minutes after the scheduled start time. I am not getting a response from your defendant, your tenant, Mr. Kevin Hamilton. How would you like to proceed this morning?
I'd like to proceed to eviction.
Ma'am, how much rent is due and owing in this matter?
8,000.
8,000 even?
Yeah,
And your court cost?
I think it was 179. I'm not sure.
Ma'am, double check what the court cost is. Case was scheduled again at 9:15. It's now 9:28 by the court's clock. Defendant having failed to appear, default judgment shall enter with $8,000 in rent due to the plaintiff, $179 in court costs. Ma'am, you will
Yes.
submit a judgment to the court with those dollar amounts on it.
Okay.
Anything else this morning, Ms. Olivero?
No, nothing else.
Thank you, ma'am. That concludes the matter. You're free to go.
Thank you.
Good morning, Darla.
Good morning.
Good to have you back.
Thank you for having me.
This is 23-00071 LT. This is Janice Bell versus Robert Jones.
Yes,
State your name, please, ma'am.
Janice Marie Bell.
Thank you, Ms. Bell. Robert Jones. Today is the day and time set for the second hearing in this matter. This is a termination of tenancy case. The defendant failed to appear for the first hearing on September 13th and has failed to appear again this morning. Ms. Bell, how would you like to proceed?
Yeah, go ahead. Yeah,
Ms. Bell, has Mr. Jones vacated the property?
he's still there.
Okay, ma'am, he's failed to appear for court this morning. You're entitled to entry of judgment for possession of the premises. The court will enter a default judgment. What you can do when you exit the room that you're in right now, exit through that door on the left, go around the corner to the civil department and submit a default judgment at the counter, okay?
Okay,
Anything else, Ms. Bell?
that's it.
Have a good day, ma'am. You're free to go.
Thank you.
You're welcome. This is a recall of 2300339 LT. This is Harbor Club versus Butler, Kilgore, and Bryant.
Yes.
Good morning, Your Honor. Raymond Court appearing on behalf of Ms. Butler.
Thank you. What happened to Mr. Morton?
He might still be in the breakout room with another attorney, Your Honor.
No, he's on his way out. I see him right now. Thank you, Mr. Morton. This is a recall of the Butler Kilgore Bryant matter. Parties have had the opportunity to speak. How are we proceeding this morning?
Your Honor, the parties have spoken. Was it Mr. Cord who represents Ms. Butler, and then the other two parties, which are improper? The parties have agreed to enter into a proposed conditional dismissal. The terms are as follows. We already placed in the record the rents retained in court costs through the month of September, including through the month of October. The total balance is $2,382.44. The parties have agreed that that will be distributed into 3 separate payments. The first one for $794.14 on 9/29, the second one of $794.14 on 10/13, and the final one for $794.16 on 10/27. The parties have all agreed to those terms in a conditional dismissal format for Kilgore and for Kaylin Kilgore and William Bryan, who are not represented by counsel. I made sure to advise them of their rights, including the fact that this agreement is not final for 3 business days. The fact that they do have the right to appeal, and they did give me permission to put their name on this proposed conditional dismissal. And then Mr. Court, who does represent Ms. Butler, agreed to those terms as well. And I'll be putting his name on the same conditional dismissal and then submitting that to the court.
Thank you. Mr. Bryant, were you able to hear Mr. Morton just now?
Yes, I was.
And sir, in the breakout room, he explained your rights to you.
Yes, you did.
And after that conversation, sir, you wish to enter the conditional dismissal with the terms she's placed on the record.
Yes, I do.
Thank you. Mr. Morton's office will prepare the conditional dismissal submitted to this court for entry. Ms. Kilgore, same questions to you. You had the opportunity to speak to Mr. Morton in the breakout room, and you understand your rights this morning.
Yes.
And after having that conversation, ma'am, you wish to agree to entry of the conditional dismissal with the terms placed on the record.
Yes.
Thank you. Do you have any questions this morning, Ms. Kilgore?
No, ma'am.
Any questions, Mr. Bryant?
No, ma'am.
Mr. Court, was that an accurate recitation of your agreement with Mr. Morton?
Yes, Your Honor.
Thank you. That concludes this matter. The court will await receipt of the conditional dismissal. Everyone have a good day. Good luck to you.
Thank you, Your Honor. I'm going to enter back into the breakout room to continue to speak to Ms. Cooper, Your Honor.
Thank you. This is 2300340 LT. This is Harbor Club versus Clinton DeSer.
Danielle Polya for the plaintiff.
I'm trying to.
Oh, jeez. Mr. DeSer, Clinton, state your name for me, please.
Clinton Desir.
Sir, this case was scheduled at 9 o'clock. You're just arriving at 9:35. Ms. Paglia, what is the rent to retain possession in this case?
I have rents to retain of $3,959.34. Court costs of $168.65 for a total of $4,127.99.
Thank you. Mr. DeSer, is that a correct amount of rent claim due and owing $3,959.34?
Yes, ma'am.
Do you have any defense to this non-payment of rent action?
No, ma'am. I just fell behind on my rent. I'm currently working with Wayne Metropolitan and DHS to help assist with me coming up with this rent money.
Thank you, sir. Inasmuch as you do not dispute the amount of rent claim due and owing in this matter, there's not a tribal issue of fact, and plaintiff is entitled to entry of judgment in the amount requested. Ms. Paglia's office will prepare a judgment with those terms submitted to the court for entry. A signed copy will be mailed to you at the address that we have on file. Do you have any questions this morning, sir?
No, ma'am. Yes, I'm just waiting on the judgment. I need the judgment form for DHS for the SCR.
Understood.
Yes, ma'am.
You'll get a copy in a few days, sir. Have a wonderful day. You're free to go.
You too. Thank you.
Thank you. This is 2300350 LT. This is Harbor Club versus Carmi Mackey.
For the record, Danielle Pauly on behalf of the plaintiff.
Carmen Mackey. This case was scheduled at 9 o'clock. It's now 9:37 by the court's clock. Defendant having failed to appear, ma'am, how do you wish to proceed?
We'd request entry of a default judgment. There's rents to retain of $6,260, court cost of $168.65 for a total of $6,428.65.
Thank you. Defendant having failed to appear for a second time in this matter, default judgment shall enter in favor of plaintiff and against defendant with a total judgment of $6,428.65. Plaintiff's office will submit that electronically for entry. This is 2300354 LT. This is Holiday West versus Raymond Shaw.
For the record, Danielle Pauly on behalf of the plaintiff.
Raymond Shaw. This case was scheduled at 9 o'clock, is now 9:38 by the court's clock. This is the defendant's second failure to appear in this matter. Based on his failure to appear this morning, ma'am, how would you like to proceed?
We'd like to seek entry of a default judgment. There's rents to retain of $2,602.96, court costs of $167.65 for a total of $2,770.61.
Thank you. Defendant having failed to appear is directed by this court for a second time. Default judgment shall enter in favor of plaintiff and against defendant with a total judgment of $2,770.61. Plaintiff's office will submit that judgment for entry. Mr. Lamon, we are still on the 9 o'clock docket. If you see some of your tenants, if you want to grab them and move them into a breakout room and discuss the matters briefly with them, the court will be taking the defaults on the 9 and the 9:15 docket.
Thank you, Your Honor. I do see a couple of mine here.
Thank you. This is 2300356 LT. This is Michigan Management versus Holly Kreitz and Nick Kreitz.
For the record, Danielle Pauly on behalf of the plaintiff.
Kreitz, CRITES. This case was scheduled at 9 o'clock, is now 9:39 by the court's docket. This is the defendant's second failure to appear in this matter. Based on their failure to appear this morning, ma'am, how would you like to proceed?
We'd like to seek entry of a default judgment. There's current rents to retain of $38,545, court costs of $187.65 for a total of $38,732.65.
Thank you. Based on the defendant's second failure to appear in this matter, default judgment shall enter in favor of plaintiff and against defendant with rent to retain $38,545, court cost of $187.65 for a total judgment of $38,732.65. This is 2300363 LT. This is Harbor Club versus Levante Reed and Cheyenne Poor.
For the record, Danielle Pauly on behalf of the plaintiff.
Reed or Poor. Today is the day and time set for the second hearing in this matter. This is the defendant's second failure to appear. Case was scheduled at 9 o'clock, is now 9:41 by this court's clock. Defendants having failed to appear, ma'am, how would you like to proceed?
We'd like entry of a default judgment. There's current rents to retain of $1,184, court costs of $190.65 for a total of $1,374.65.
Thank you. Based on the defendant's second failure to appear in this matter, default judgment shall enter in favor of plaintiff and against defendant with a total judgment of $1,374.65. Plaintiff's office to submit that judgment for entry. This is 2300333 LT. This is Harbor Club versus Aurelia Bogde, Bogde.
Danielle Paulia for the plaintiff.
Thank you. Today is the day and time set for the second hearing in this matter. This case was scheduled at 9:15. It is now 9:42 by this court's clock. Defendant having failed to appear, ma'am, how would you like to proceed?
Would be seeking entry of a default judgment. There's current rents to retain of $3,145, court cost of $168.65 for a total of $3,313.65.
Thank you. Based on the defendant's failure to appear in this matter this morning, default judgment shall enter in favor of plaintiff and against defendant. Total judgment, $3,313.65. Plaintiff's office to submit that judgment for entry. This is 2300335 LT. This is Harbor Club versus Asia Brown and Khalif Hampton.
Danielle Paulia for the plaintiff.
Brown or Hampton. Today is the day and time set for the second hearing in this matter. The case was scheduled at 9:15, is now 9:43 by the court's clock. This is the defendant's second failure to appear in this matter, ma'am. Based on their failure to appear, how would you like to proceed?
Your Honor, we'd be seeking entry of a default judgment. There's current rents to retain of $6,775, court cost of $190.65 for a total of $6,965.65.
Thank you. Based on the defendant's failure to appear for a second time in this matter, default judgment shall enter in favor of plaintiffs and against defendant with the total judgment of $6,965.65. Plaintiff's office to submit that judgment for entry. This is 2300549 LT, Gateway Townhomes versus Tremaine Townsend. May I have your appearances, please?
Yes, good morning, Your Honor. John Berncran for Gateway Townhomes.
Ma'am, state your name for me, please.
Tremaine Townsend.
Today is the day and time set for the second hearing in this matter. The parties have had the opportunity to speak. Mr. Berncran, how are we proceeding this morning?
Yes, Your Honor, I'm happy to report that we have agreed to the entry of a consent judgment for possession only. The rent owing is $2,656. It does not include October's rent, plus $166 in court costs for a total of $2,822, which must be paid by no later than Monday, October 9th, 2023, or else Ms. Townsend would have to vacate the apartment by that date. She's also agreed for me to sign her name to such a consent judgment. I've explained that she has 3 days to come back to court, business days to come back to court and ask the court for a hearing if she feels that she has a reason to do so. And it's up to the court at that point to schedule a hearing. And I've indicated that she has until Monday, October 9th, 2023 to appeal such a judgment.
Mr. Berncran, the day will actually be October the 10th.
Oh, I'm sorry. Is Columbus Day? Okay. The courts are closed.
It is.
Okay.
Other than that, Ms. Townsend, were you able to hear Mr. Berncran just now?
Yes, ma'am.
And ma'am, that's how you wish to proceed with a consent judgment showing $2,656 in rent, $166 in court costs for a total judgment of $2,822.
Yes, ma'am.
And ma'am, you understand that because you're not represented by an attorney, you have 3 days to come back and ask this court not to enter that judgment.
Yes, ma'am.
And you have 10 days to appeal any decision of this court.
Yes, ma'am.
And because you appear by Zoom, there's not a signed consent judgment. You've authorized Mr. Berncran to sign your name to the consent?
Yes, ma'am, that's correct.
Do you have any questions this morning?
If I were to do the appeal, I meant to ask Mr. Berncran before, if I were to do the appeal, how would I do that?
Ms. Townsend, what's the issue, ma'am?
The issue is that I was explaining to Mr. Berncran, that I know that the date is, well, now the 10th, but I don't get paid until the 13th. And I know that he can't, do it past the 10 days, but I was just asking, if I could have just an extra couple of days till my pay date.
What date are you looking for, Ms. Townsend?
My payday is on the 13th, which is that Friday.
Okay, and will you be able to pay October's rent as well?
Not by that date, no, ma'am.
Okay, Mr. Berncrant, would you go back into the breakout with Ms. Townsend? There's still some earlier cases that this court needs to call, and you may be able to work out something that resolves the issues that might be remaining between the two of you.
I would be happy to do so, Your Honor. We did address this subject. My concern was the same as the court's concern, that this figure that we have now does not include October. And if we have to push the payment date, my concern is that October's rent would be due as well. And I was attempting to explain that to her, that it's favorable to her because we're late in the month of September, that because October's rent has not yet come due. But I can certainly talk to her.
I'm sorry. We can leave it the way that we have it. That'll be fine.
Ms. Townsend, I don't want you to do it if that's not something you're comfortable with, because when you're asking about an appeal, then that means that there's some other issue outstanding. And if we can address it, I'd rather address it.
Okay.
So do you want to speak to Mr. Berncrant further?
Sure.
Okay, I still have some earlier cases, so Mr. Berncrant, please go back in there.
Okay, very well, Your Honor.
Thank you.
Thank you.
This is 2300336 LT. This is Harbor Club versus Casharo Burnett.
For the record, Danielle Hawley on behalf of the plaintiff.
Hey, how you doing?
Burnett, thank you. Turn your video on, state your name for me, sir.
Casharo Burnett.
Thank you. Today is the day and time set for the second hearing in this matter. Ms. Paglia, what is the rent to retain possession?
Rents to retain is $3,912.20. Court costs of $168.65 for a total of $4,080.85.
Mr. Burnett, were you able to hear the attorney just now?
Yes.
Is the amount of rent claim due and owing accurate?
Yes.
Do you have any defense to this non-payment of rent action?
Yeah, I just was in a tight spot. I had lost my granddad.
I'm sorry, sir.
I said I was in a tight spot. I had lost my granddad a few months ago. Just been, getting myself back on track. Start working next week.
Well, Mr. Burnett, in as much as you don't have a legal defense to the amount of rent claim due and owing, there is not a tribal issue of fact, and plaintiff is entitled to entry of judgment in the amount requested. That total judgment would be $4,080.85. Ms. Paglia's office will submit that judgment to the court for entry. A copy will be mailed to you at the address the court has on file. But Mr. Burnett, in as much as you're indicating that you have a financial hardship right now, what I will have you do before you leave this session is go into a breakout room with Ms. Rimke from Wayne Metro Eviction Prevention. She may be able to connect you to some financial resources, okay?
Okay.
Anything else this morning, Mr. Burnett?
No, ma'am.
Thank you, sir. Keep an eye out for that invitation to join the breakout room with the representative from Wayne Metro, sir. Good luck to you.
Okay, thank you.
Thank you. This is 2300337 LT. This is Harbor Club versus Julian Brown and Emily Sample.
For the record, Danielle Pauly on behalf of the plaintiff.
Julian Brown or Emily Sample. Today is the day and time set for the second hearing in this matter. The defendants failed to appear at the first hearing and failed to appear at the second hearing. How would you like to proceed this morning, ma'am?
Your Honor, we would seek entry of a default judgment. There's rents to retain of $960, court costs of $190.65 for a total of $1,150.65.
Thank you. Based on the defendant's failure to appear, default judgment shall enter in favor and plaintiff and against defendant with the terms just placed on the record. Anything else in this matter this morning, ma'am?
Nothing further, thank you.
Thank you. This is 2300905 SP. This is Park Avenue Requisitions versus Nicole Nolan and Ryan Nolan.
Good morning, Your Honor. Jeremy Brown on behalf of plaintiffs.
Nicole Nolan or Ryan Nolan. This case was scheduled at 9:15. It's now 9:52 by the court's clock. This is the second hearing in this matter. Based on the defendant's failure to appear, sir, how would you like to proceed?
We would like to proceed with the entry of the judgment of possession after a land contract forfeiture. The amount to reinstate as of today is $7,205.66. That is less than 50% of the purchase price. So I'd like the order to say if they don't, cure this within 90 days, the writ can be issued.
Based on the defendant's failure to appear as directed by this court, plaintiff is entitled to entry of the relief sought. Mr. Brown, if you would have your office submit the judgment that is appropriate for the facts of this case, the court will enter it. Anything else this morning, sir?
That's all, Your Honor. Thank you.
Thank you. Have a good day.
Too.
Thank you. This is 2300098 LT. This is Robert Patterson versus Philip Walsh.
Robert Patterson, Your Honor.
Thank you. Philip Walsh. Today is the day and time set for the second hearing in this matter. The defendant failed to appear at the first hearing. This case was scheduled at 9:30. It's now 9:54 by the court's clock. Defendant has failed to appear again, sir. How would you like to proceed?
I would like a possession judgment, and default possession judgment, and also I'd like let's see where I've got this here. The court further order that the redemption period shall be terminated pursuant to MCL 600.3238, paragraph 10.
Mr. Patterson, inasmuch as the defendant has failed to appear this morning, the plaintiff is entitled to entry as requested. Please complete the judgment form submitted to the court for entry. Anything else this morning, sir?
No, ma'am.
Have a good day, Mr. Patterson. You're free to go.
Thank you.
This is 2300362 LT. This is Harbor Club versus Smith.
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of the plaintiff.
Catherine Cooper on behalf of the defendant, P85148.
Thank you. This is a recall of this matter. How are we proceeding this morning?
Your Honor, the parties have spoken and have agreed to enter into proposed conditional dismissal. The terms are as follows. Was it as of today's date through the month of September? Rents retained are $3,742, court costs of $168.65 for a total of $3,910.65. As of November 1st, that total balance due will be $6,830.65. We've agreed to allow until November 1st, 2023 to make that payment based off of assistance programs that Mr. Smith is proceeding to seek. Additionally, he will be making 3 separate payments during the interim. First one is on 10/9 for $400. The second one is on 10/16 for $200. And the third one is on 10/23 for an additional $200. And again, the parties have spoken and have agreed to those terms, and we will submit that as a conditional dismissal unless Ms. Cooper feels like I said something that was inaccurate in our resolution.
I do not, Mr. Morton.
Thank you. Ms. Cooper, the court has noted the file with the terms placed on the record by Mr. Morton. If the parties would execute it and get it submitted to the civil department as soon as possible, I'd be ever so grateful. Anything else in this matter, Mr. Morton?
No, Your Honor.
Your Honor.
Anything else, Ms. Cooper?
Not for this matter, but I do see Ms. Remke. I didn't know if she wanted to speak with Mr. Smith. He contacted Wayne Metro yesterday. I don't know if you guys want to go into a breakout room really quickly or no. Silence. Okay.
No. Mr.
Okay.
Smith, if you need to follow up with the representative from Wayne Metro, she is here. We can connect you with her before you leave the session.
Okay. Yes.
Okay. Anything else, Ms. Cooper?
No, Your Honor, that's all for me.
Thank you. Mr. Smith, you should see an invitation to go into a meeting room with Ms. Remke from Wayne Metro. Please go there. Have a good day, sir.
Okay, thank you.
This is 2300162LT. This is Frank Vandercook and Bertha Vandercook versus Gary Taylor.
Yes, I'm here, Your Honor.
State your name, ma'am.
Bertha Vandercook.
Oh,
Thank you. Where is Mr. Vandercook?
He's right here behind me in the room. He's
Thank you.
94 years old, so.
That's fine. Thank you, sir. Gary Taylor.
Anthony, can you guys drop a check off to me today to made payable to Hands Party Store Inc. That amount that I typed.
I'm sorry. Mr. Nasu?
Can you do I'll bring it like whatever certified or the holidays where it's like not, they can't like cancel
Sir?
it.
Mr. Nafsu, are you, thank you. Gary Taylor, this case was scheduled at 9:30, is now 9:58 by the court's clock. Defendant having failed to appear for a second time in this matter. Ms. Vandercook, how would you like to proceed?
I would just like possession of the apartment, please.
Ma'am, you filed this as a non-payment of rent action.
Yes,
You have to proceed with the non-payment of rent judgment. What is the rent to retain possession?
would be $2,400.
And do you know what your court costs are to date?
No, I don't.
Ma'am, the court will enter a judgment in favor of plaintiff and against defendant with rent to retain possession of $2,400. You should also include your court costs to date. Submit that judgment to the court for signature.
Okay,
Okay?
okay.
Anything else this morning, Ms. Vandercook?
Can I ask her about possession? Are we allowed to go into the apartment at all? Take any
No, ma'am.
possession? Okay.
No,
'cause
ma'am,
He's not
because
been
the
there in
judgment will
over 4
indicate-
months.
I understand, ma'am, the judgment will indicate that the defendant must pay within 10 days or vacate the property. Until that time, they have a legal right to continue to occupy the premises.
Okay,
Anything
Thank
else,
you.
Ms. Vandercook?
no, that should take care of it. Thank you. Your
Thank you,
Honor.
ma'am. You have a good day. You're free to go.
You too, thank you.
Thank you. Is Mr. Berncrant, you're back. This is a recall of 2300549LT Gateway versus Townsend.
Yes, John Burngrant for the plaintiff, Your Honor. Again, to Ms. Townsend, and she's in agreement to what we had agreed to that I put on the record previously.
Ms. Townsend, unmute yourself for me, please.
Can you hear me?
Ma'am, yes, ma'am, thank you. When the court called the case the first time, you had some concerns about your payment, your pay date being the 13th and the pay by date for this matter being October 10th. Have your issues been addressed and resolved?
Yes, ma'am.
And ma'am, you wish to enter a consent judgment that indicates that you owe $2,822 in its entirety and that you will pay that amount or vacate by October 10th?
Correct.
And you've authorized Mr. Berncrant to sign your name to the condition, I'm sorry, to the consent judgment with these terms?
Yes.
Do you have any questions or concerns that remain this morning, Ms. Townsend?
No, ma'am.
Thank you. That concludes this matter. Mr. Berncrant will submit the consent judgment to the court for entry. A signed copy will be mailed to you at the address we have on record. Ms. Townsend, there might be financial resources available to you. This court has a representative from Wayne Metro on this morning. Would you like to meet with her?
Sure.
Ma'am, you'll see an invitation to go into the breakout room with Ms. Remke from Wayne Metro. Please go there, speak to her.
Right, thank you.
You're very welcome.
Thank you, Your Honor. Have a good day.
Thank you. You too, sir.
Thanks.
Mr. Lamon is not back yet. This is 2300263LT. This is Belleville Point versus Kathy Slater.
Good morning, Your Honor. Rebecca Austin for plaintiff. Your Honor, this matter was going to be dismissed.
Thank you, Ms. Austin. I will make a note of that on the docket, that the Slater matter will be dismissed. Thank you. This is 2300265 This is Bell Point versus Robert Lee.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Robert Lee. Mr. Lee,
Yes.
unmute yourself. State your name for me, sir.
Yes, ma'am. My name is Robert Lee.
Thank you.
Good
Today
morning.
is the day and time set for the second hearing in this matter. Ms. Austin, what is the rent to retain possession?
Rent to retain, Your Honor, is $2,792. Court costs of $161.15. The total is $2,953.15.
Mr. Lee, were you able to hear Ms. Austin just now?
Yes, ma'am.
Is the amount of rent claim accurate?
Yes, ma'am.
Do you have any defense to this non-payment of rent action?
You currently working with,
I'm currently working with Wayne Metro.
and Ms. Remke was supposed to represent you.
And Miss
I'm sorry,
Remke,
who is that speaking to you, sir?
This is my wife.
Good morning.
Good morning, ma'am.
He has a disability, so we're supposed to have been talking with Ms. Remke. Ms. Remke was supposed to represent him this morning. We spoke with somebody from Wayne Metro yesterday.
Okay, ma'am, I can't let you represent him unless you're an attorney in the state of Michigan. He's doing a good job.
Okay,
But
I'm
if the
sorry.
issue is, no, you're fine. If the issue is a financial hardship, that's not really a defense to the non-payment of rent action. It's something that the attorney will note for the file, and this court will note in the file that you're working with Wayne Metro to access financial resources that may be available to him.
Okay. Okay.
Mr. Lee, did you already spoke to someone from Wayne Metro?
Yes, ma'am.
You've made application for financial assistance?
Yes, ma'am.
I will note it in the file. Ms. Austin will note it in her file, but sir, in as much as there is not a legal defense to this non-payment of rent action, plaintiff will be entitled to entry of judgment as requested. That would be $2,792 in past due rent, $161.15 in court costs for a total judgment, $2,953.15. Ms. Austin's office will submit that judgment to the court for entry. The court will sign it and the copy will be mailed to you at the address we have on file. Do you have any questions this morning, Mr. Lee?
No, ma'am.
Judge,
Ma'am, you have a question?
I do. He has a worker at Wayne Metro, but they can't get the documents from the landlord. They were unable to obtain them. So if we can get those, I can expedite.
I'm sure that Ms. Austin will relay that to her client. I don't understand landlords who don't participate when there are financial resources available. I understand it might not be as quick as they'd like it to be. But Ms. Austin, if you would encourage your client to participate to the
Yeah,
extent
absolutely, Your
necessary
Honor.
to. Thank you.
And they're normally
Anything
receptive.
else?
I apologize for any delay. I mean, normally it's, yeah, we get the things out as soon as they need them.
Anything else, Mr. Lee?
No.
Thank you. That
Thank you.
concludes this matter. You're free to go. This is 2300270 LT. This is Belleville Point versus Kamira Cheatham.
Good morning, Your
Cheatman,
Honor.
sorry.
For plaintiff.
Cheatham, you were right. It's Cheatham.
Is it spelled wrong on our end? Today is the day and time set for the second hearing in this matter. Ms. Austin, what is the rent to retain possession?
Your rent to retain, Your Honor, is now only $231. Court cost of $161.15. The total is $392.65. Ms. Cheatham had made a $1,000 payment 2 days ago.
Ms. Cheatham, is the amount of rent claim due and owing accurate?
Yes.
Do you have any defense to the non-payment of rent action?
No.
Ma'am, in as much as you admit and acknowledge the amount of rent claim due and owing is accurate, there is not a tribal issue of fact and plaintiff is entitled to entry of judgment in the amount requested. Ms. Austin's office will submit a judgment for $392.65 to the court. The court will sign it and copies will be mailed to you at the address that we have on record. Anything else this morning, Ms. Cheatham?
No.
That concludes the matter, ma'am. You're free to go.
Thank you.
This is 2300271 LT. This is Belleville Point versus Michael Bujak.
Good morning, Your Honor. Rebecca Austin. for plaintiff.
Morning.
Good morning.
State your name, please.
Michael Bujak.
Amanda Bujak Phillips.
Thank you. Today is the day and time set for the second hearing in this matter. Ms. Austin, what is the rent to retain possession?
Your Honor, this has been paid in full and will be dismissed.
Any objection to the dismissal of this matter, Mr. Bujak and Ms. Bujak?
No.
Plaintiff's office will submit that dismissal to the court for entry. You're free to go. You have a wonderful day.
Thank you, you too.
Thank you. This is 2300635 LT. This is Romulus Housing versus Hill.
Morning, Your Honor. Steve Hitchcock appearing on behalf of the Romulus Housing Commission.
Shajona Hill. This case was scheduled at 9:45. It's now 10:08 by this court's clock. Defendant having failed to appear, sir, how would you like to proceed?
I'd like to proceed with the default judgment. This was a case based upon a 30-day notice to quit, so we want a judgment for eviction.
Thank you, Mr. Hitchcock. Based on the defendant's failure to appear this morning, the default judgment shall enter in favor of plaintiff and against defendant. Have your office submit that judgment electronically for entry. Anything else this morning, Mr. Hitchcock?
Nothing further. Thank you, Judge.
Thank you, sir. Have a wonderful day.
You too.
Thank you. This is 2300539 LT. This is BSP 2 versus Marion Caldwell.
Your Honor, good morning. Douglas Swadish appearing on behalf of BSP 2 for the plaintiff.
Marion Caldwell. Marion Caldwell? I thought I heard a response, Mr. Swadish.
I did too, Your Honor.
Marion Caldwell? Okay. This case was scheduled at 9:45. It's now 10:09 by the court's clock. I thought I heard a response, sir, but there's no one responding further. Defendant having failed to appear, sir, how would you like to proceed?
Your Honor, we asked the court to enter a default judgment. This is a termination of tenancy case. So the writ would issue, I believe, 10/10/2023. There is some back rent owed and plaintiff is seeking a monetary judgment as well. The total.
That amount would be, sir?
The total rent is $3,490 and there's $110 in filing fees. So total judgment would be, I'm sorry, the total rent is $3,380, $110 in filing fees. So the total judgment would be $3,490.
Please submit that judgment for entry. Anything else, sir?
No, Your Honor. Thank you very much.
Thank you. Have a good day.
You too, Your Honor.
Mr. Lamon, I passed your matters because you weren't back out yet, but there are people here. So that's the reason why I asked you to come out just now.
Your Honor, that's
This
fine.
is-
I was talking with Ms. McLemore about one of the cases, but I know there's a couple of other tenants present.
There have been people here since 9-ish, and so I want to get them on their way. This
Certainly.
is 2300502 LT. This is Park Estates versus Stephen Morgan.
For the record, Daniel Landman appearing on behalf of the plaintiff.
State your name for me, please, Mr. Morgan.
Stephen Morgan, STEPHEN Morgan.
Thank you. Today is the day and time set for the second hearing in this matter. Mr. Lamon, how are we proceeding this morning?
Your Honor, the current rent to retain is $1,169.61. There's costs owed of $168.28 for a total of $1,337.89. I met with Mr. Morgan in a breakout room and he claims he's paid in full.
Mr. Morgan,
Ma'am,
when did you pay this amount in full, sir?
August was paid on time, ma'am. And she somehow, some way, Parker State is still taking me to court. And September is paid on time, ma'am, because I paid a late fee every month because I'm always late because I'm the way my job is getting me the money, but I get the money to them every month on time. In the 30 or 31 days that I've been living in this community for 13 years, I've tried to pay my rent on time. So September is paid for, but I still get court dates to go to court to pay for court that the rent is paid for. August paid on time. When September 1st came, I only owed September 1st. But then when I got the rent to them, I still had to go to court the 13th. And then I got the rent to them that Friday, but I'm still going to court to pay for September. That's paid for. They got me in court for something that's getting paid every month with late fee.
There's a representative here from Park Estates who should be able to confirm whether or not that's been paid.
That's correct, ma'am. It's paid. But I've been an adult in adult work for 37 years, and I know a slumlord when I know a slumlord, Your Honor. And they are wrong in what they're doing. Coming down here not being.
Ms. Kobish, yeah, she's unmuted now.
So I'm sorry, Mr. Lamon.
I was just indicating Ms. Kobish is unmuted now. She was muted before.
Hi, Your Honor. This is Kim Kobish, the community manager at Park Estates. So he dropped off $610 at the beginning of September for August. And then I just got another $610 in the Dropbox when I came in yesterday. So there's still a balance from our records showing $103.18, and we don't take partial payments. So I have the two money orders sitting here waiting.
So the amount of rent claim due by Mr. Lamon is not correct. If you're holding money and there's actually a balance of $103.
Yep, that's what we show on our records.
Mr. Lamon.
Your Honor, again, if the money is being held to be applied post-judgment, I would take the position that the balance that I am showing on the ledger would be accurate. Obviously, the second the judgment is entered, then money can be applied as under paragraph 6 of the judgment. Partial payments would not prevent the issuance of an order of eviction. Where I am a little bit confused is if $1,220 is being held, what would be left over is $117.89 rather than $100. So I'm not sure what that discrepancy is unless it's the discrepancy in the court cost.
Well, Mr. Lamon, again, Mr. Morgan is disputing this amount. So what I would like to do is schedule this matter for hearing where the parties will present the ledger and the payments. Can have you come back next Wednesday, the 4th in the morning, if you're available, Mr. Morgan.
Yes, ma'am. I would have to take off work again if it's scheduled.
No, you don't have to take off. No, sir. I don't like people to take off work for a hearing that should only last 15 minutes if it's just a question of ledger and payments.
Oh, okay.
What time do you get off of work, Mr. Morgan?
I can do this while I'm out here, ma'am. I'm in between with the UAW strike, so I can pull off to the side of the road and take this. It's only like a 15-20 minute bid. Yep. I'm in the auto lanes, ma'am, so I can pull over.
I hear you. I'm looking at the 4th first thing in the morning, and the 4th at 9 a.m. Mr. Lamon, could you have someone here with, not here, but on Zoom with the ledger?
Yes, Your Honor.
And
Mr. Morgan, next Wednesday, the 4th at 9 a.m.
Yes, ma'am, and that is state where this $103 or $117 is coming from? Because I don't know where it's coming from.
Mr. Lamon and Mr. Morgan, if there are documents that you want the court to consider for this October 4th, 9 a.m. Zoom hearing, have them to the court by 3 o'clock on this Friday, the 29th, okay? Anything else, Mr. Lamon?
No, Your Honor.
Anything else, Mr. Morgan?
No, ma'am. Thank you.
Thank you, sir. I'll see you next Wednesday morning at 9 a.m. on Zoom.
Yes, I will. Thank you very much. Bye-bye.
Thank you. This is 2300504 LT. This is Park Estates versus Rice.
I'm here.
Danielle
State
Landsman
your
on behalf
name.
of the plaintiff, Your Honor.
I'm sorry, ma'am. Daphne Rice.
Thank you. Today is the day and time set for the second hearing on this matter.
Yes.
Ms. Rice, you failed to appear for the first hearing. Mr. Lamon, what is the rent to retain possession in this matter?
Your Honor, the balance provided by my client is $1,862.12. There's costs of $168.28 for a total of $2,030.40. I believe there is about $600, maybe slightly more, that Ms. Rice has tendered to be applied to that total upon entry of judgment.
Ms. Rice,
Yes, ma'am.
were you able to hear Mr. Lamon just now?
Yes, ma'am.
Is the amount of rent claimed owing accurate
Yes, ma'am.
after the application of the $600?
Yes, ma'am.
Ms. Rice, do you have any defense to this non-payment of rent action?
No, ma'am.
Ma'am, inasmuch as you acknowledge the amount of rent claim due and owing is accurate, plaintiff is entitled to entry of judgment in the amount requested. Mr. Lamon's office will prepare a judgment that shows that amount and acknowledges the $600 as being held. Do you have any questions this morning, Ms. Rice?
Yes, I can make the payment, but of my balance, but because of the strike, we've been off for 2 days, and I know I have by law, is it 10 days to pay?
Yes, ma'am.
Okay, would they allow me to pay that Friday so I can make up, because I will be $200 short. But because of the strike, we make parts for Ford and Chrysler. We've been off for 2 days.
Ms. Rice, the court does not typically get involved in how tenants make payment arrangements, but there is a representative on this morning from Park Estates. Ms. Kobish has heard you indicate that you are a striking worker.
Yes, ma'am.
I would suggest that you stay in contact and communication with their office.
Okay.
Partial payments will prevent a writ in this matter, Mr. Lamon.
I will make that change on the judgment, Your Honor.
Thank you. Ms. Rice, that doesn't mean that you don't pay. That means that you pay, but you remain in contact and communication with the office, okay?
Yes, ma'am, I definitely will.
And Ms.
Anything
Rice-
else, Ms. Rice?
Yeah, Ms. Rice, may I ask you the exact amount that you have tendered that they're holding?
I think I'm at work, sir, and I'm not allowed to bring any paperwork, not even my backpack inside right now. So I think it's 600 and Miss Kim, I just talked to her, 600 and maybe 650, I think. And I don't like to guess because that.
Okay, I'm just trying to
a
make
lot of
sure the
trouble.
paperwork is correct. Ms. Kobish, what is the amount?
$670.
Very good, thank you.
You're welcome.
Anything else, Ms. Rice?
No, so I do have time to, I'm so sorry. My boss is giving me to come in. So I do have the 10 days, and then if I needed the extra days, I go inside and talk with Miss Kim.
It's not even extra days, ma'am. Have a plan that you can speak to someone in the community about. Don't
Yes,
wait
ma'am.
until the 10 days are up,
Oh,
okay?
thank you. Oh, no, I definitely won't. I won't.
Anything else?
No, ma'am.
You're free to go, ma'am. You have a wonderful day.
Yes, ma'am, you too.
Thank you. This is 2300597 LT. This is Maple Leaf South versus Vernon Glass.
Daniel Landsman for the plaintiff.
Vernon Glass. Today is the day and time set for the second hearing in this matter. This case was scheduled at 9:30. It's now 10:21 by the court's clock. Defendant having failed to appear. Mr. Lamon.
Your Honor, plaintiff moves for the entry of a default judgment for possession only. Based on my client's books and records, rent to retain is $2,031.23. Costs are $168.28 for a total of $2199.51. we'd request that an order of eviction be allowed to be entered after October 9th if that amount is not paid in full.
Thank you. Default judgment shall enter in favor of plaintiff and against defendant in the amount claimed due by the plaintiff. Anything else in this matter, Mr. Lamon?
No, Your Honor.
Thank you. This is 2300632 LT. This is Maple Leaf South versus Alicia Smith.
Daniel Landman for the plaintiff.
Alicia Smith. This case was scheduled at 9:30. It's now 10:22 by the court's clock. Defendant having failed to appear for the second time in this matter, default judgment shall enter in favor of plaintiff and against defendant. The rent to retain possession, Mr. Lamon.
Your Honor, rent to retain, based on my client's books and records, is $1,963.50. Costs are $168.28 for a total of $2,131.78.
Thank you. Mr. Lamon, have your office submit a judgment with those terms on it. Does that conclude your docket with us this morning, Mr. Lamon?
Your Honor, no, we have one other case for.
Oh, I see it.
For.
2300272 LT. I'm sorry.
Yes, it's Park
Mr.
Estates.
Lamon, I'm
versus
sorry. Go
Chambers.
ahead.
Park Estates versus Chambers, Your Honor. That's the case that Ms. McLemore is on.
Morning, Your Honor. Your Honor, Danette McLemore, and I am appearing on behalf of Ms. Chambers. Ms. Chambers is currently in a breakout room. Mr. Landman and I had been discussing a possible resolution in the matter. I did want to.
Ms. McLemore, I'm sorry. I'm looking for the case.
Okay, I'm sorry.
No,
And
no,
I
you're
have
fine.
I will file an appearance today, Your Honor.
I'm 2300500 LT. This is Park Estates versus Chambers.
Yes,
Daniel Landman for the plaintiff, Your Honor.
and Ms. Chambers is currently in the courtroom.
Hello, Station Chambers.
Thank you. Ms. McLemore, how are we proceeding? Ms. McLemore?
I am so sorry, Your Honor. One of the foibles are working at home on Zoom. Dogs. Sorry about that. In any event, I did speak with the attorney for the plaintiff in this matter, and we were speaking about a conditional dismissal with terms to catch up. But I was concerned, or we were speaking about the new rules that go into effect, the court rules in the state. My client does have an SER application and a Wayne Metro application for rental assistance pending, and I'm not sure if the court rule is in effect as of yet for the stay.
It's not. It's November 6th.
Okay. Then could you recall this a second time so that I can just confirm with Mr. Landman what we were discussing in terms of the proposed conditional dismissal?
Absolutely.
Thank you, Your Honor.
Thank you. This is 2300272 LT. This is Belleville Point versus Randall.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Ms. Randall, state your name for the record, please, ma'am.
Janice Randall.
Thank you. Today is the day and time set for the second hearing in this matter. Ms. Austin, what is the rent to retain possession?
Rent to retain, Your Honor, is $1,876.50. Court cost of $161.15. The total is $2,037.65.
Ms. Randall, were you able to hear Ms. Austin just now?
Yes.
Ma'am, is the rent to retain possession that she placed on the record accurate?
Yes.
Do you have any defense to this non-payment of rent action?
No.
Ma'am, inasmuch as you admit an auction amount of rent claim due and owing is accurate, plaintiff is entitled to entry of judgment as requested, that total judgment being $2,037.65. Ms. Austin's office will submit that judgment to the court electronically for entry. A copy will be mailed to you at the address that is on record with this court. Ms. Randall, do you need to speak to a representative from Wayne Metro regarding potential financial assistance in this matter?
Yes, and I was also hoping to speak with the landlord about a possible payment arrangement.
Ms. Austin, are you in the position to discuss a payment plan with her?
I am, Your Honor.
Then we'll do this. Ms. Randall, you'll go first into the breakout with Ms. Austin and then with Ms. Remke from Wayne Metro after you speak with her.
Okay, thank you.
After you speak with her, you're free to go, okay?
Thank you.
Thank you. Mary Ann?
Yes, ma'am.
I don't understand your statement.
Mr. Hamilton was here right after you called the case. He appeared later, and Asia Brown came in about a half hour late. I just wanted to let you know.
Where's Mr. Hamilton?
Kevin Hamilton is up on my screen on the top screen.
With the blue shirt on? Mary Ann?
Yes.
The gentleman with the blue shirt on?
Yes.
That's the wrong Mr. Hamilton.
Oh, okay. Thank you.
I know, we went through this. It's a weird coincidence, but it's not the Mr. Hamilton that I seek. And then for Ms. Brown, 2300335 LT, Harbor Club versus Asia Brown.
Asia Brown, good morning.
Turn your video on for me, please, ma'am. Ms. Brown, your case was scheduled at 9:15. The court called it at 9:43.
Yes, I was under the influence today that my court was at 10:15. This is my second court. My first one was at 10 o'clock. So I guess that's where the confusion came in at. That's my apologies.
Ms. Brown, I'm looking and it appears that the attorney from Harbor Club is no longer here. He indicated on the record that there is past due rent of $6,775. Is that correct, ma'am?
Yes, it is.
Ma'am, inasmuch as you acknowledge the rent claim due and owing is accurate, the court would have entered judgment even with you here in that amount. Do you need to speak to someone about possible financial assistance that might be available to you?
Yes, I do.
Ms. Brown, the court will enter the judgment that the plaintiff's attorney requested previously. It will be mailed to you at the address we have on record. But the next thing you'll see is an invitation to go into a breakout room with Darla from Wayne Metro. Please go there and talk to her about financial resources that may be available to you, okay?
Okay, thank you.
Thank you, ma'am. We're back on Park Estates versus Chambers, 2300500.
Once again, Your Honor, Daniel Landman on behalf of the plaintiff.
And again, Danette McLemore on behalf of the defendant, Ms. Chambers. Your
How
Honor,
are we proceeding, Ms. McLemore?
We did have an opportunity to discuss the matter. We reached a resolution in the matter, and at present, there is a balance owing of $3,331.18. We've agreed to entry of a conditional dismissal order, and the defendant will be paying. She will be making a payment this Friday of $1,200. On October 13th, she will make a payment of $1,300. And by the end of October 31st, 2023, she will pay the remaining balance of the $3,531 plus the October rent. And I will prepare a CD in that matter and forward it to Mr. Landman for his approval.
Thank you. The court will note that a conditional dismissal will be forthcoming from the parties. Anything else, Mr. Landman, in this matter?
Your Honor, only that the balance is $3,531.18. The payment schedule that Ms. McLemore outlined is correct.
Thank you. Anything else, Ms. McLemore?
No, Your Honor, Ms. Chambers is present in the courtroom, and again, I did review that agreement with her, and again, she is in agreement.
Thank you. That concludes this matter. Ms. Chambers, you're free to go. Good luck to you. Have a good day.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. This is 2300331 LT. This is NME Group versus Nails by T.
Good morning, Your Honor. Daryl Nafsu on behalf of plaintiff.
Nails by T. Today is the day and time set for the second hearing in this matter. Defendant failed to appear for the first one. This case was scheduled at 9:45. It's now 10:32 by the court's clock. Defendant has failed to appear again, sir. How would you like to proceed?
Your Honor, we are requesting a default judgment against the defendant in this matter.
Based on the defendant's failure to appear, default judgment shall enter in favor of plaintiff and against defendant. Sir, if you would have your office submit that judgment to the court electronically for entry, it'd be most appreciated. Anything else?
No, Judge. Thank you and have a great week.
You too. Thank you. This is 2300307 LT. This is Markel Spencer versus Edith Gibson.
Yeah, plaintiff Markel Spencer here.
Good morning, Your Honor. George of Lakeshore Legal Aid on behalf of Edith Gibson, who's also present in the Zoom courtroom.
Mr. George, when did you file an appearance in this matter?
I thought I did so last week, Your Honor, but I'll double check on that. And if I haven't, I will do so today.
Thank you. Today is the day and time set for the second hearing in this matter. I don't know, Mr. George, if you had an opportunity to speak to Mr. Spencer or the other representatives from Spring Hill.
I did not, Your Honor. However, I don't expect that this case will be going forward today in any event, as Ms. Gibson did. I understand she filed a demand for a jury trial.
That is correct, sir. There was a demand for a jury trial. But the court's question would be, what is the tribal issue?
Your Honor, Ms. Gibson has several defenses, including repair defenses, quiet enjoyment. And I have questions whether this case was properly filed in the first place, as the ledger that I have and that Ms. Gibson filed along with her answer shows that on the date of filing, the balance was zero or close to it.
Yeah, so with that, Ms. Gibson actually back in August, I did a chargeback with the balance.
Your phone, thank you. I got it to work on my.
Yep, so a chargeback was done to the hotel for $3,748.96. Since then, from July 21st till today, we haven't received any payment from Ms. Gibson. So the balance that's owed on top of the $3,748.96 would be $10,939.50. In total, that would be $14,688.46.
I haven't seen an updated ledger, Your Honor.
So, Mr. George, what I'll have you do is go in and speak to Mr. Spencer and the other representatives from Spring Hill. The court's concern is scheduling a jury trial for a case that the parties have not had the opportunity to speak.
I'm happy to speak with Mr. Spencer, Your Honor.
Thank you. In the
Your
interim,
Honor,
let's recall two, I'm sorry, go ahead.
I did just have a quick question. Was this case filed with a supplemental complaint checked? The copy that I have, it wasn't clear to me.
I'm pulling it up right now. Give me one moment.
Thank you, Your Honor.
No, sir.
No supplemental complaint?
No, sir.
Okay, thank you.
Well, I'm sorry. No, there's not a supplemental complaint, But there is a notice to quit attached to the complaint that's dated 7/24 for Ms. Gibson to vacate by 7/26. And this case was filed as a non-payment of rent case.
That's correct, Your Honor, as far as I understand.
So for my record, Ms. Gibson was actually supposed to leave the property by the 26th, and on the 26th, she never left. So we just went ahead and filed for an eviction since she was not leaving.
Mr. Spencer,
Yes,
there's two different types of case. There's a termination case and there's a non-payment case.
yes. So when I went down to the courthouse, I was told to issue the first one for demand of possession. So that's what I went ahead and did. And when she didn't leave the premises, I was told to file for the landlord tenant, since she wasn't trying to vacate.
Okay, Mr. Spencer, maybe I'm not being clear to you. There's two types. If you gave her termination notice, it's you must vacate the premises.
Yes,
The different notice is the non-payment of rent,
yes. So
a demand for payment. I don't see it in the electronic file that I'm looking at. Before you go on it with Mr. George, I just want to make sure that, was there something else filed?
yes, I have it right here. And it received on July 31st from the court that I got a non-payment of rent as well.
Okay, no. Mr. George, you understand my question?
I think so, Your Honor.
Okay,
It appears that perhaps the wrong kind of case was filed, given the notice that was sent out. So that would be another defense that we would be seeking to assert.
Mr. George, I answered the question regarding the supplemental complaint. There is not one checked. Please go into the breakout room. When you come back out, I'll recall this matter and I'll clear up the rest of this docket. Thank you.
Thank you, Your Honor.
Ms. Austin, you had a payment plan in 2300272.
I do, Your Honor. Did you want the terms placed on the record?
Yes, please.
All right, Ms. Randall is gonna pay $1,100 by October 10. She's gonna pay the remaining $937.65 by October 13, and then she's gonna pay October's rent and late fee by October 27.
Is that correct, Ms. Randall?
Yes.
I'll make a note of it on the court file, ma'am. Other than that, any questions this morning, Ms. Randall?
No, I don't have any more questions.
Then you're free to go, ma'am. You have a wonderful day.
You too. Thank you.
Thank you. Joe Semifero? Two 3000333 LT Harbor Club versus Aurelia Bogda. Ma'am, state your name for me, please. Ma'am with the red short sleeve shirt on. Ma'am,
Yes,
state your name for me, please.
Aurelia Bagde.
Ms. Bagda, your case was scheduled at 9:15. I called it at 9:42 and you were not here. The attorney was here and indicated that there is past due rent of $3,145. Is that amount correct?
Yes,
Ma'am, inasmuch as you agreed to the amount of rent claim due and owing, the court would enter judgment for that amount. The plaintiff's office is submitting a judgment with that amount on it with 168.65 in court cost. A copy of that judgment will be mailed to you at the address we have on record.
Okay. How much time
Was there
do I
anything
have?
else this?
How much time
10
do I
days,
have
ma'am.
to? Pardon me?
10
10
days.
days? 10 days?
Yes, ma'am.
Can I have like 15 days to come up with the whole amount?
The attorney is not here for us to discuss that, ma'am.
Oh,
So please, ma'am, be in contact and communication with the landlord's office, the property management, okay?
okay.
Anything else?
No, I just wanted to, but if the attorney is not there, I can't do anything about it. I just needed more time, but I'll do my best to come up with the
Just talk
amount.
to someone in the management office, okay?
Okay, thank you so much.
Thank you, ma'am. Have a good day.
Thank you, you too.
Clerk, are you there?
Darla, it doesn't look like you're in the office today.
No, I was having some difficulties with the internet. They're doing trees in the backyard and it affected me for a brief moment, but I'm back. I do apologize.
Don't apologize. I just still haven't made it next door, that far walk from our building to your building to say hello in person.
I'll give you side door access. I'll be there tomorrow.
Are you a regular 8 to 4, 9 to 5 person?
9 to 4, yes.
9 to 4, okay. I have ordinance docket in the morning, but as soon as I finish that docket, I will meander over.
That would be wonderful. I would love to meet you in person and we could go over a few things and get to know what the services are and how we can assist.
Thank you. I heard one of was it Ms. Cooper indicate that there is money available for 6 months of rent?
Up to 6 months arrears, yes, if they are eligible. And also, we have new funding coming October 1st, as long as the government doesn't shut down.
I do need to come over and chit chat with you about that because I was EDP attorney back at the beginning of all this in July of 2020. So it's been a while since I was in the throes of it.
Okay, okay.
Oh, they're all together now. Okay. We are back on the record. And
Your Honor, I think Ms. Gibson is still in the breakout room. Ah, here she is.
we're back on the record in 2300307 LT. I have your appearances noted for the file. Mr. Spencer and Mr. George, I wasn't trying to complicate the matter further, but I did see the jury demand and I have concerns when there is a termination and a non-payment case kind of smashed together. But you've had the opportunity to speak. Mr. Spencer, how are we proceeding?
Yes, we would like to proceed with an emergency eviction. The defendant has not attempted to pay us. She refuses to leave. We tried to ask her to leave back in July. We gave her the opportunity to be free of all legal and financial obligations if she would have left, and she continues to stay in the room and not cooperate. We get continuous noise complaints from the defendant's room, and it's causing a burden on our business. And of course, as us as a hotel, we've been not able to rent that room out for months and not collect anything on that room.
Your Honor, may I speak? Julie Ellison, owner representative of the hotel.
Yes, ma'am.
Thank you, Your Honor.
I'm sorry, before you do, Ms. Allison, do you intend as Mr. Spencer, Ms. Allison, do you intend to retain an attorney to represent the interest, or will you be conducting the jury trial?
Well, obviously, we thought at this point that we would be able to resolve this matter and that the guests would be gone by now. Back as he said in July, we were just going to let her leave. She did this at one of our other hotels as well, and she left. And so in July, we were going to let her leave with all financial obligations gone, just to get her out of the hotel. But then she didn't, and now she refuses to leave and she refuses to pay. So at this point, I thought today that I just got involved in this case as the owner representative. So I wasn't really familiar with it. It got kind of far before it got in my hands. Once I became aware of what was going on, at this point, I was hoping that we would get an emergency judgment to have her removed from the premises as soon as possible. I didn't know what had been filed and what had not. But at this point, she refuses to pay and she refuses to leave. And that's where we stand at this moment. She just disrupts other guests. We have to move people. We've lost a lot of revenue from this room and continue to do so. And she refuses to leave. She's not leaving. So at this point, we'd like some direction on if we need to get an attorney, that's no problem. But she's just not paying at all.
Mr. George?
Thank you, Your Honor. I think that the presentation from the plaintiff leaves out some important context here. Ms. Gibson is not a Michigan resident. She has a severely disabled daughter who uses a wheelchair. She brought her daughter here for medical treatment, and that's the reason that she was staying in the hotel. Because her daughter is in a wheelchair, it's very difficult to move her around. Ms. Gibson has attempted to leave on several occasions and has scheduled flights, but has been unable to leave the hotel because it seems like every time she schedules it, either she runs into a problem with the hotel itself, like the elevators being down, so she can't move her daughter, or she gets ill. So it's just, she's been trying to leave for months now, and it just hasn't worked out. She's stranded here in Michigan trying to get medical care for her daughter. As far as the noise complaints, her daughter has intellectual disabilities as well as physical disabilities, as I understand. And she does make noise, but again, Ms. Gibson is trying to vacate. She just needs someplace else to go and needs to have access to the elevators and to the help that she needs to get her daughter out of the room.
Thank you. Mr. George and Mr. Spencer, there was a motion to vacate that was attached to Ms. Gibson's improper filings. That motion is dated September the 6th. Court staff did review the matter with me before the My Resolve hearing. There is a request from Ms. Gibson to vacate this case to ensure that the presiding federal district court can provide the appropriate relief under federal law. I told the court staff that we would take it up at today's hearing. The implication is that there is a pending federal case that will require this matter to be stayed, not vacated, but stayed. Mr. George, are you aware of any federal filing in this matter?
I am not, Your Honor. I believe that Ms. Gibson is considering filing a separate matter in federal court. But as far as I'm aware, there is no currently pending matter.
In as much as there is not, the court will deny the motion to vacate, which is should actually probably be captioned a motion to stay. And I only wanted to clear it up because it shows as an open motion in the court. Additionally, the defendant has requested a jury trial, which she has a right to. And Mr. George, you've articulated some possible defenses that would be set off to the non-payment of rent complaint in this matter. So then the question becomes, how soon would you be prepared to conduct a jury trial in this matter?
I don't think that there's going to be a whole lot of documentary evidence. I think I could be prepared within a couple of weeks, Your Honor. I'll leave it to the court's discretion.
Mr. Spencer,
Yes.
how long would it take you to be prepared for a jury trial in this matter?
As soon as possible.
The issue is that it takes 3 weeks for us to summon jurors. And that is why I wanted you to speak to each other this morning. If there's any narrowing of the issue, the court has read, there's a huge pack of information. There's probably 50 pages of filings from Ms. Gibson that alleges some behavior from staff, involvement of police and things of that nature. This at its essence is a non-payment of rent case. So before jurors are summoned,
We believe that this is a stall tactic on her part. This is what she's doing to allow herself to have a few more weeks of being in a hotel for free, Your Honor. The case is pretty obvious. It's pretty straightforward. She refuses to pay, refuses to leave. And that's it in a nutshell. So whenever you would like us to be ready, we are, but it's quite clear. She's just using this as a way to continue to stay in our hotel for free at no cost and refuses to pay.
today is the 27th. 1, 2, 3 weeks puts us the 18th. But there's a notice time that puts us the week of Thanksgiving. I'm just trying to find a good date.
Be 8
Looking
months. She would be staying at our hotel for free. Refusing to pay.
I'm sorry?
for 8 months. Do you, to go that long, do you, I know, I understand there's a time element, but I just want to point out the fact, Your Honor, that's 8 months she'll be staying in our hotel for free and refusing to leave, and refusing to pay.
Miss Allison, I understand, but if she was there in May and there was no action taken in June or July, I can't make the case go any faster than it goes. I can't make the period to notify jurors any shorter. 3 weeks is the absolute minimal amount of time that our jury clerk needs to get the packet together and get it out. This
I
court
under-
also has to make sure that there is not something else scheduled, another jury scheduled in the building for that day. This court's actual jury week is not the week that is not a month from now. It's not until the last week of November. So we have to make sure that none of the other judges, none of the other courtrooms will be utilizing jurors that last week of October. I'm looking at potentially October 30th, which is not our jury week, Mary Ann. Mr. George, do you see any resolution of this matter short of trial?
I would note that Ms. Gibson is working with some folks from the state of Michigan trying to find alternate housing. Since there was no supplemental complaint, if she vacates, then I would hope the case would just be dismissed and there would be no need for trial.
Is that a conversation you're prepared to have with the representatives from Spring Hill today regarding a vacate date that would resolve this matter in its entirety?
Seeing as Ms. Gibson is still working with the state of Michigan to try to find alternate housing, I don't believe that we could set a date today. However, I would certainly reach out to Mr. Spencer and see if we could come to a resolution after she vacates, and we could submit something to the court so no one has to appear.
May I speak?
Mr. George, your client wants to say something.
Yep, I was waiting for you, Your Honor. What do you have to say, Ms. Gibson?
The deputy director from Wayne County Central Administration Office called Mr. Spencer in order to find out what was going on so that they could provide assistance. He interfered with my ability to get assistance from the state of Michigan. And so they have my emergency request on hold because of the conversation that he had with the deputy director. And she's also willing to appear as a witness if this case goes forward in trial so that she can testify as to what Mr. Spencer told her. And as far as the payments that were made, I have record from my bank statement that those payments did go through. They were not charged back as Mr. Spencer continues to defraud the court in stating that no payments have been received. There have been a total of 7 payments that has been received. 3 of the payments were made by me and 2 of payments were made by a nonprofit organization. And then 2 payments were forced through my account. It has 2 different dates, one of June 9th, and then the other date that's forced through, it says June 21st. July 21st, which is also information that's been provided in the answer.
Okay, thank you, Ms. Gibson.
Mary Ann, I'm looking at Halloween,
Okay, give me 1 second.
Tuesday, the 31st. Yes, thank you. Or Friday, the 3rd.
Judge, both of those dates are open. There isn't anything going on in the court. Well, I don't mean that. I mean, but it's good for a jury trial.
I was looking at, I don't see anything else scheduled in the building on Halloween. Or Friday the 3rd. I just don't want to step on anyone else's. Mr. Spencer, do you have a preference, October 31st or November the 3rd?
I'm okay with October 31st.
Mr. George?
I think the 31st will work better for me, but it's a close call, so either one is fine.
The 31st at 9 a.m.?
Your Honor, will this be an in-person hearing?
For a jury trial? Absolutely.
I figured. I live in Grand Rapids, and so I will have to drive out. I could make 9 a.m. work, but if we could do later, that would make it a little bit easier for me.
Later is difficult for jury summoning. That's my concern. So
I
if 9
understand, Your
a.m. is
Honor.
doable for you, I hate to
I'll
push,
just drive
but
out the
9
night before,
a.m.
Your Honor. Yeah, I'll just drive out
Okay.
the night before and spend the night.
So October 17th will be the deadline to file witness and exhibit lists and propose jury instructions. Mr. George and Mr. Spencer, if you come to some resolution of this matter and you are able to reduce it in writing, to writing 1, 2, 3, sometime between now and next Friday, that would allow this court not to have to summon jurors for the 31st. So we're looking at October 6th for a resolution in writing. Other than that, the court will be looking for the proposed witness and exhibit list and jury instructions by October 17th.
Okay.
Anything else, Mr. Spencer?
No, Your Honor.
Anything else, Mr. George?
So how do we
No,
get?
thank you, Your Honor.
How do we get in touch with Mr. George?
Mr. Spencer, I will put all of my contact information in the chat,
Okay.
and you can confirm that you see it there.
Okay. Yep, I got you.
All right, and if you could just send me a quick email with your contact information, I would appreciate that.
Okay.
Anything else, Mr. George?
No, thank you, Your Honor.
Thank you. I will see you all on Halloween, October 31st at 9 a.m. Have a good day.
Thank you, Your Honor.
Thank you.
Thank you, ma'am. Good to see you. Mr. Friedman,
Good morning.
good morning. For reasons that are not clear to me, your case does not seem to have made the docket. It was adjourned over for a week, and I see Ms. Hawkins here.
I don't know what the problem is, Your Honor, because last week there was an issue about the docket. And you specifically put it on for today at 11.
I know. And I'm just pulling up the electronic file of it now. This is 233434 LT. This is U.S. Government versus Karima Hawkins. Your appearances, please.
Ellis Friedman for the plaintiff.
George of Lakeshore Legal Aid on behalf of Karima Hawkins, who I see here in the courtroom.
Thank you. Today was the day and time set for the continued hearing in this matter. Mr. Friedman, was there anything else you'd like to say on behalf of your client?
As last week you indicated that if we had anything else to file it by Friday, which I did. I filed a order from the United States Court of Appeals, Sixth Circuit, affirming the Tennessee's district court decision, forfeiting the property to the United States government and declaring that Karima Hawkins had no interest in the property whatsoever. That federal district court order was affirmed by the Sixth Circuit Court of Appeals. So now we have a United States Court of Appeals opinion affirming the district court opinion that the property belongs to the United States government and Ms. Hawkins has no interest in it. Therefore, I would prefer to move on with my termination of her quote unquote tenancy and recover the possession of the property for the United States government.
Mr. George,
Yes, Your Honor. I also submitted some documentation. I submitted, I'm sorry, Your Honor. Did you not receive any documentation?
I did not from you, sir.
No?
Neither did I.
Mr. Friedman, you received something from Mr. George?
No.
I am pretty certain I saw it come through on my file. I apologize. Yeah, I have a my file receipt here.
When did you file it, Mr. George?
It was filed Thursday, 1:45 p.m. And the filing included the Register of Actions from the Third Circuit Quiet Title, the Register of Actions from the Tennessee federal case, the civil case to recover the property, the amended complaint, and the original complaint from that case.
The quiet title action of the Third Circuit's my client's the plaintiff. And that's to eliminate some old liens and things on the property. But my client is the plaintiff in that case. This is not a case that was brought by Ms. Hawkins. There's some.
That is correct, but my understanding is Ms. Hawkins is involved in the case, attempting to establish her interest in the property.
Well, at this point, I have the United States Sixth Circuit Court of Appeals saying that she doesn't own the property and the U.S. government does. And I don't know how anybody in a quiet title action or in any other action is going to overcome that, unless she gets a writ from the U.S. Supreme Court. I think this case should be over.
And Mr. George, after our hearing last week, I did have the opportunity to review the order Mr. Friedman referenced, and it does appear to make it clear that Ms. Hawkins does not have an interest that would upset the forfeiture order previously entered relative to this property.
Excuse me, Your Honor. She's attempting to attack that judgment collaterally in a civil context rather than a criminal context via that civil case in the Tennessee District Court. So again, we're just looking for a stay on these proceedings pending the outcome of the quiet title action and the Tennessee collateral action.
The quiet title action is a red herring. It's just it's to eliminate some miscellaneous claims which mostly have been resolved. It's not designed to have any impact on the decisions that were made by the federal district court and for the Middle District of Tennessee, nor the United States Court of Appeals. There were some old liens and things that they wanted to clear up, but
I have to admit that I'm a little confused. If Ms. Hawkins did not have an interest in the property, why she would be named in that quiet title action.
because she keeps claiming she does, but she doesn't.
And Mr. George, this court would concur with Mr. Friedman in its reading of the orders that have already been issued. It does not appear that Ms. Hawkins has an interest in the property and that plaintiff is entitled to its possession judgment. Unless there's something you want to specifically direct this court to at this time, this court is prepared to enter a judgment in favor of the plaintiff and against defendant.
I'm afraid I don't have anything further, Your Honor.
Thank you. That being the case, this court will find that the orders from the federal court make it clear that there is no the orders from the federal court make it clear that plaintiff is entitled to entry of judgment as previously requested. Mr. Friedman, if you would have your office submit a judgment to this court to return possession to the plaintiff, the court will sign that and get it back to the parties.
We'll get it filed here shortly.
Anything else, Mr. Friedman?
Not today.
Anything else, Mr. George?
No, thank you.
Thank you. That concludes this matter.
Thank you, Your Honor.
All right, Ms. Hawkins.
And that
I'm gonna-
concludes this court's docket. I'm sorry, go ahead, Mr. George.
I just wanted to address Ms. Hawkins. I'll follow up with you via telephone this afternoon, Ms. Hawkins.
Thank you.
That concludes this court's docket for the day. We stand adjourned.
Have a great day, everyone.